I really appreciate the opportunity to kind of have a conversation about my line of work as it interacts with the mental health system and your line of work. I've taken great pride in, I think the public defender's office generally tends to represent some of our most vulnerable friends and family and peers in our communities. But my caseload in particular, I think, tends to really hone in on those even more vulnerable, with the kids that I represent, the parents facing termination of parental rights, and definitely in the mental health realm. I think easily some of my most vulnerable and most in need clients are those who have substance abuse issues, and very commonly substance abuse issues kind of filtering into and overlapping with and exacerbating mental health issues that would render them subject to what we call a Chapter 51 civil commitment, or an involuntary commitment, which, as I explain to my clients, a commitment order is basically a court order that says you have to listen to what your doctor says. You lose that autonomy to say no to your doctor. And the law and the Constitution permit that under certain circumstances. We, as a country and as a community, have accepted principles where we'll infringe upon people's individual civil liberties under certain circumstances. You know, you commit a crime, you might lose your liberty to walk around and you'd have to stay in jail or prison. And in the mental health realm, if you're doing something that is potentially dangerous, you could lose that freedom and to exercise your own autonomy over your own mental health, and a lot of times overlap with physical health as well. And so I love my job. I love my job in protecting the due process rights of individuals. And invariably, like as I alluded to, in doing my job, sometimes there's conflict with people who are witnesses or prosecutors or family members of my clients who will take the position more often in a contested case that this person needs help, and why are you helping them not get help? And I get that. That's a rational position to take. But I look at it from the standpoint of, if I ensure that the Constitution is followed, that the statutes are followed, that the legal process is followed, a couple things then happen. One is that my clients tend to feel more okay with the outcome that they didn't want. If they felt fought for, if they felt like it was a fair process, and then the outcome still isn't what they want, at least they had their shot. At least they had somebody advocating for what they wanted. And two, I think, you know, even in broad systems with many people overlapping and many people wanting to help an individual, sometimes mistakes of law are made. And so my job is to just hold everybody accountable to make sure that they're following the law. And so I take great pride in my job, even when it has to be confrontational at times. So for this particular audience, I identified a couple learning objectives that I thought maybe my perspective from the legal end, and more specifically from the legal defense end, might be appropriate for healthcare professionals. And so learning objective number one, I'd like you to walk away from our conversation today with the ability to identify the legal process by which patients are subjected to Chapter 51 commitments. It's a complicated process. It's tedious. There's a lot of procedural requirements. And I just want to give you an overview of that so that you know both what your patients might be going through if they're subjected to one of these processes, and where you might be interacting with them along that path. Second learning objective, identify and practice some of the legal limits to expert opinion testimony for medical staff in Chapter 51 commitment proceedings, because I mentioned before we get started that I've given presentations to law enforcement on this topic as well. And if you don't know before you go in about like the rules of evidence and what you can and can not testify to, at least under the law, that then you're setting yourself up for some, you know, sleazeball defense attorney to nitpick you and make you look silly. And so I think the better approach is for everybody to kind of have an understanding of what the law permits you to talk about. And I'll kind of give you that sense, and we can practice that from the standpoint of the defense attorney. And then number three, practice some formal and informal interactions with defense attorneys and prosecutors in these cases. And also, as I alluded to, sometimes my interactions with healthcare professionals in an individual case aren't fun. It's, will you talk to me? No. Okay. Will you accept the subpoena by email? No. Okay, that's cool. We'll track you down with a person. And I think that just forecasting or role playing some of those interactions from my perspective, and just give you practice to see, okay, if I'm going to be involved with a patient who might be subject to one of these proceedings, what is it that I can expect with regard to both the defense and the prosecution? What are the lawyers going to talk to me about? And then if we want to even break it down further, I call this my down and dirty learning objectives. You know, if you can take a couple things away from the presentation that I think are most practically beneficial to you, at least to the extent that you might testify in one of these hearings, here are my 2 down and dirty learning objectives. And we'll talk about these as we go too. One being, just because you know something doesn't mean you can say it in court. There's rules about what you can say and what foundation you need to have to be able to say it. And sometimes, and most witnesses, and I think medical professionals who tend to have access to a lot of information about a client, don't know what those rules are. And so we'll talk about kind of some of the rules about what you can and cannot say. And then the second rule is to stay in your lane. And I say that, you know, that phrase in society tends to be derogatory, but I really mean this is just kind of like objective, like, what is your expertise and what is your role in testifying in these cases? And I think very often I'll see a witness, a doctor, a nurse, practitioner, a nurse, whoever, testifying on behalf of the prosecution in one of these cases. And they really want this person to get help. And so they try to offer a lot of information that maybe the law doesn't permit them to say. And then I get to use that against them, that they're biased for a particular outcome. And in reality, the prosecutor is probably going to do a good job of kind of checking all the boxes to make sure that they can present a case. So those are our down and dirty learning objectives. So starting with learning objective number 1, the legal process by which people are subjected to Chapter 51s. I think there's an extra slide in there. Okay. So when I started doing this work, maybe a decade ago, I'm a visual learner, and I think that phrase gets overused, but I guess I wanted some diagram to help visualize, okay, what the heck's going on here? Like, what does this process look like? And I came up with this. And this is about as clear as mud. There's like ors in there. There's alternatives. There's different time claims. I have this floating little 2 doctor reports filed up in the top middle. Like, what's that connected to? I don't know. But to me, this was the best way and simplest way to kind of visualize how a Chapter 51 civil commitment process goes. And this is pretty complicated. And so I would just say, you know, this yeah, it could make your head hurt. And this process is very, very confusing, even to the practiced attorney, let alone the person involved in the case in non kind of legal fashion. The treatment provider for the person, the doctor, the nurse, the staff, whoever, it's a very complicated process. So we'll kind of break it down. There are 4 different ways in which a legal civil commitment case gets started. And I call this case commencement. Like, you know, in family court, you know, 2 people are getting divorced, they file a petition for divorce. If somebody slips and falls and they want to sue the person who didn't clean their sidewalk, you serve them a summons and a complaint that you're going to sue them. Those are legal ways to start a court case. And in Chapter 51 civil commitment, there are 4 different ways to start this process, to initiate the legal proceedings. And the most common one that I see in my practice is what's called an emergency detention. And an emergency detention is when law enforcement comes upon a person, and for however they got there, maybe there was a call, maybe they just happened to see him, but law enforcement comes upon a person and they take that person into custody, not necessarily to arrest them and accuse them of committing a crime, but what we call a protective custody or custody for the purposes of an emergency detention. And when the person is taken into custody, and then one of the options that the police officer will have will be to say, well, I don't want to arrest this person, but I think based upon, what I know about this process, they might meet the criteria for a civil commitment. So I'm going to detain them for the purposes of a civil commitment. And they have to fill out this form. And this is the legal form that we call the Statement of Emergency Detention by Law Enforcement Officer. And essentially, this is the initiating document of the court case. So back to our example of like a petition for divorce or a complaint because you want to sue somebody because you slipped and fell on their sidewalk. Those are the legal documents that initiate the case. You file them with the court. You say, I want to start this case. Court gives you a court number. And they say, okay, cool. There's a legal proceeding that started, and it started because you filed this paperwork. That's what this is in a civil commitment. It is the court initiating paperwork. And it's set up pretty simply to allow the law enforcement officer to kind of do it as efficiently and appropriately as possible. But what they have to do is they have to say that they have reason to believe that a couple things are true. Okay, this officer who's starting this case has to have reason to believe that the subject is either mentally ill, drug dependent, or developmentally disabled. And a lot of times there's kind of like dual diagnoses or overlap of those categories. So they've got to have some reason to believe that one of those things is true. They have to have some reason to believe that this person that they've interacted with and taken into custody is engaging in behavior that might be dangerous. And the law under Chapter 51 talks about the ways that somebody could be dangerous. The law defines what dangerous means for one of these cases. And so the officer has to think that, yeah, this behavior falls into one of those categories. And then the officer has to think that taking the person into custody is the least restrictive alternative appropriate to the subject's needs. And really that speaks on the legal side of things to being whether they're voluntary or not. Usually, like, we don't take people into civil commitments if they're knocking on the door at the ER saying, I'm having a mental health crisis and I need help. That's not the person you take into custody for a civil commitment. You take somebody into custody for a civil commitment if they're not seeking that help on their own voluntarily. So when law enforcement fills out this paperwork, they actually have to get approval by a medically trained person. And this person doesn't have to be a medical doctor, an MD, but they have to meet some basic legal criteria for medical training. And then the county picks which entity it wants to use to approve these emergency detentions. And in Dane County, we use a unit of Journey Mental Health called Crisis. The Crisis unit, the intake unit at Journey Mental Health, they have a contract with Dane County so that when a law enforcement officer has reason to believe that these three things are true and they're filling out this form, they actually have to call somebody who's on call at Crisis to say, hey, I want to detain this person for a Chapter 51 for an ED. Is that okay? Here's what I got. And they fill in some information. They provide the crisis worker with some information. And the crisis worker says, okay, yeah, I think you've got what you need for a Chapter 51. I'll approve this emergency detention. And so that person has to be included on the form. There's a section on the form that says, blank of the blank County Department of Community Programs approves the need for this detention. So again, in Dane County, we've contracted with Journey Mental Health. They have people on call 100% of the time, 24 hours a day, 7 days a week, for law enforcement to call and say, I would like to initiate an emergency detention of this person. Here's what I know. What do you think? And so Crisis will approve that. Then, as I said, there's 5 different ways under the Chapter 51 law that somebody can be deemed dangerous. So when a law enforcement officer has to have reason to believe that this person poses a risk of dangerousness, that reason to believe has to be based upon one of the 5 legal standards. And I'll summarize them real quickly right here, and we'll talk about them in a little greater detail later. But one of them is a substantial harm to themselves. Usually manifested by a suicide attempt or suicidal statements. Number 2 is a substantial harm to others if they're doing something violent that puts people in fear of their own safety. That could be considered a second standard of dangerousness. There's the gravely disabled or a pattern. The third standard involves a pattern of behavior where they're evidencing impaired judgment, that they can't take care of themselves, or could put themselves in harm's way, which is a little different from the 4th standard, which is that they're not able to meet their basic needs. I've had a lot of clients who need dialysis but don't acknowledge that they have kidney failure. They might probably fall under that 4th standard. And then the 5th standard that me and my biased defense attorney hat think it's totally unconstitutional, because all it says is that this person would decompensate to the point that they would need a commitment if we don't force them to take medication. But the ability to refuse psychotropic medications is kind of established in the constitutional case law, that that's a constitutional right. So it's kind of this circular logic on that 5th standard, and I'll keep challenging it until it gets deemed unconstitutional. But that's what that 5th standard is.
I have a question.
Yeah, please.
If you go back 2 slides.
One more, that one.
Yep. So I'm just confused. How does it work for, because it's a and statement for the first line? If someone has in the situation of delirium, let's say they're not going under dialysis, so they would be a grave danger to themselves. But what would that fall under for the first prompt?
No, that's a great, absolutely great question. And so usually what happens is that when of these 3 criteria that the law enforcement officer has to have reason to believe, the first one is the hardest for them to pinpoint. Okay, because really, the subjects, you can't determine their mental health needs or whether they're drug dependent or whether they're developmentally disabled until they're actually seen by a medically trained professional. And so when a law enforcement officer is doing this kind of initial analysis, it's sufficient for them to just kind of observe behaviors and make a common sense conclusion that this probably isn't in the realm of somebody who's completely mentally healthy right now. And they'll usually talk to the crisis worker on the phone who is trained in certain diagnoses on these 3 categories to say, hey, I saw the person exhibit XYZ behavior. What do you think? That person will say, well, I'm not, I'm not certified or trained to diagnose, but I know diagnoses, and that certainly sounds like it might fall into the category of bipolar disorder, a schizoaffective disorder, a developmental disability. And so this initial taking them into custody, they don't really have to prove that point. They just have to be like, yeah, this probably makes sense. This doesn't fall into the category of what we would call either normal or asymptomatic behavior or thinking. And what happens then is that when the person, going back to our diagram here, between the point at which they're taken into custody and then the 72 hours before they have what we call a probable cause hearing, which I'll explain in a second, they're taken into custody at somewhere with medical treatment providers. And so they'll go to UW Hospital's, B65, or they'll go to 1 East at Meriter, the locked psychiatric unit, or St. Mary's now, SSM, has their psychiatric unit on the 6th floor, or Stoughton has their locked Jerry psych unit, or Mendota has its locked Jerry psych unit, or more commonly, they're driven all the way up to Winnebago Mental Health, where they're detained there. And then in that 72 hours post-detainment, they will be seen by a medical professional. And then when the prosecutor wants to say, okay, I need to, at this first hearing, I need to at least show that these 3 things could be true, otherwise this case is going to get dismissed, they're probably going to call the officer, but they're most certainly going to call some medical professional who has treated the person in those initial 72 hours between detainment and the first hearing to say, hey, have you evaluated this person? How long did you spend with them? What are your credentials? Do you think that they meet the criteria for a mental illness under the DSM-5 or a drug dependency or a developmental disability? And so even though a law enforcement officer is kind of tasked to make kind of an initial inquiry into this very specific area of expertise, it's really once they're detained that the prosecutor will obtain a witness to testify to that first element. That make sense and answer your question okay?
Yeah, that was great. Thank you.
All right. So kind of just I alluded to as part of that question that there's 72 hours between when the person is taken into custody and when they have to have their first what we call a probable cause hearing. And the probable cause hearing is very similar to like a criminal prelim, where it's like this first check to say, okay, prosecution, you don't have to prove your case yet, but like, is there enough here that we should even let this case go forward, go to trial, move forward? Or should we just dump it right now because you're missing a clear element? So probable cause is just a check at the beginning to make sure, could this get to the point? Do we have a reason to believe that the elements for a Chapter 51 commitment are true? And there's very, very strict case law that hearing needs to occur within 72 hours of when the person was taken into custody. And under Wisconsin statutes and Supreme Court, U.S. Supreme Court case law, that 72-hour window doesn't count weekends and it doesn't count legal holidays, but it's 72 hours when you count business days. And when I say it's jurisdictional on this, I mean that if the hearing is not held in those 72 hours, the court loses the ability to do anything in the case. They lose jurisdiction. Jurisdiction is the legal authority to make decisions and orders over somebody, and you can't do that in a 51 if you let it go more than 72 hours. The time that the 72-hour window clock starts is usually the issue or can be an issue of litigation. I'll tend to argue if it's close in the 72 hours that my client was in custody earlier than the prosecution is saying, to see if I can squeeze out the timeline such that the hearing was held too late. But there are some general principles that when a law enforcement officer comes in contact with a person, they tend to be voluntary until they're not. And that means that if the officer's talking to them and having a discussion and they're complying, then that's fine. They're probably not in custody yet, and the 72-hour window hasn't probably started yet. And I wrote no false choices in here because I've seen officers say, well, you can get in the car by yourself, or I can cuff you and drag you there. Well, at that point, you're probably in custody because you don't actually have the freedom to make a choice to walk away. So that 72 hours is really, really important for law enforcement officers and lawyers, less important for medical professionals, but that's usually the time where that person needs to evaluate the subject, the patient, to make sure that the prosecutor has a witness to say, yep, this person is either mentally ill, developmentally disabled, or drug dependent. So that's our most common, these EDs, where officer comes in, takes custody. But there's a couple other ways for a case to commence. And I put this on here kind of tongue in cheek. I actually filed this motion back in 2018. I put Dr. Sager's name on there with his permission before he moved to New Zealand right at the beginning of the pandemic. He worked at St. Mary's, wonderful dude, really, really smart. And I got a case dismissed from a patient of his who was at St. Mary's. And he initiated a treatment director's hold after the case was dismissed. And I about lost my mind because a treatment director's hold is, under the law, is when a person gets to the hospital or the medical place, the treatment facility, in some either voluntary fashion or certainly not by way of an emergency detention. So maybe they go to the hospital and they say, I need help. And then they're like, I want to leave. And then somebody who's designated as the treatment director of the facility can say, yeah, I don't feel like it's safe for you to leave. I'm initiating a treatment director's hold and you can't leave. And so that gives medical professionals the ability to treat somebody who comes in contact with the hospital, the clinic, wherever, who may want, came in initially seeking help, probably needs the help, but then changes their mind. And Dr. Sager, and this didn't get litigated or anything. We had a good discussion about it, and then we got the subjects in voluntary treatment. But one of the ways you initiate a treatment director's hold is not if the case gets dismissed and then you just stop the person from leaving and ignore the court order that says the case is dismissed. It's got to be some voluntary mechanism for which the person gets to the hospital. And I say voluntary, it could be that they were like unconscious in a car accident and just not through an ED, not through an emergency detention do they get there. And then once they're there, if they want to leave and the medical staff says, no, we don't think that's safe, they can initiate a treatment director's hold and hold the person to initiate the 72-hour window and then the Chapter 51 proceedings. So a little joke there again. Dr. Sager's a really nice guy. He gave me permission, but and then moved to New Zealand, because I'm sure it's very beautiful there. Another way that one of these cases can start is called a three-party petition. And what that is that, the person is exhibiting behavior, and the three people, the three parties, tend to be a medical professional, a family member, and then either one of those again or some other person who's had contact with this person, but they haven't had contact with police such that they've been taken into emergency detention. And so it gives family members, treating doctors, treating nurses, treating professionals the opportunity to say, this person needs help. We think they meet the criteria for a 51, and they haven't been taken into custody yet, but we can put together what amounts to an affidavit, like a sworn statement of we think these things are true, and we can get the case started. The hitch to this that a lot of people don't understand when they initiate this is that it still needs to go to the prosecutor, to Corporation Counsel, which is the office of lawyers who represent the county in civil matters, not criminal matters like the DA. They have to still sign off on it, and they still have to prosecute it. And so oftentimes they do when presented with a three-party petition, but sometimes they choose not to, and they explain to the three parties usually why they're not going to pursue it. But this is a way where if three people collectively can get together and allege the person's dangerous, they're not getting treatment on their own, and they're either mentally ill, drug dependent, or developmentally disabled, then here, prosecutor, here, Corporation Counsel, please initiate this Chapter 51 commitment proceeding. So that's another way to do it. And the last way is what I call a post-criminal commitment. And so when somebody is charged with a crime, there are two ways that they can be committed as part of that criminal case. One is that they're found NGI, which is a derogatory acronym, and it's an acronym of derogatory terms that doesn't even appear in the statutes anymore, but it's still referred to in the legal community. I don't know why. But NGI stands for not guilty by reason of insanity. That term isn't used in the law anymore. It's not guilty by reason of mental disease or defect. And so if they're found NGI, they can be committed. And so they're not sent to prison like the crime or jail, but they could be sent to a treatment facility to receive treatment, even in a locked manner, for the length of what their criminal sentence could have been. And that's the same for somebody who's not competent. The Constitution says, as interpreted by many, many courts over many, many years, that we can't prosecute people who, if they don't fully understand the process, that's just not fair. And so similarly, if someone's found not competent after being alleged to have committed a crime, they can be civilly committed, not sent to prison, but sent to a treatment facility for the length of the term of what their sentence could have been for that crime. When those commitments end, the Chapter 51 law allows Corporation Counsel to pursue a post-criminal commitment that says, okay, they've been in custody for this length of time, and they still pose a risk of dangerousness, and they still won't get it on their own, so we're going to start a Chapter 51. And in that case, they'll usually have witnesses testify who have treated the people over time, maybe from Mendota Mental Health, for example, here in Dane County, and then they will initiate the Chapter 51 proceeding that way. So once the case is initiated, we have this probable cause hearing, where the person has a right to be present, although that's being litigated in the courts of appeals after COVID. It's supposed to be at the place of detention if that place of detention is less than 100 miles from the courthouse. The rules of evidence apply, basic due process rights apply, and the subject actually has a right to a 7-day adjournment, which if you're a witness in one of these cases, you might be subpoenaed by Corp Counsel. And then like 20 minutes before the hearing, they might call you and say, yeah, the subject exercised their 7-day adjournment. We'll see you in a week. And they have that right, and it's not discretionary, and it just happens usually for strategic reasons from the defense. but that's kind of how some logistics of that first hearing. Probable cause. What is probable cause? It's a pretty low burden of proof. And burdens of proof are the degree of certainty that a court must have in order to make a decision. And a court will allow a commitment case to move forward at the probable cause stage if there's basically some reason or probable cause, probable reason to believe that the subject meets the criteria for a commitment. It's not preponderance of the evidence. The final hearing is by clear and convincing evidence. And in criminal cases, we do beyond a reasonable doubt. So these probable cause hearings is pretty low burden of proof for the prosecutor. And so I wanted to kind of pose a question. This is kind of a sneak peek for just in a little bit. If the rules of evidence apply, which I haven't really explained to you yet, and if the principles of due process apply, how will the prosecutor show that the subject is mentally ill? And quite frankly, our wonderful question that we had addressed that issue already, where the law enforcement officer probably can't, offer an opinion that the person's mentally ill. It's going to take somebody who's treated the person while they've been held on those first 72 hours. So great question. Once the probable cause hearing occurs, the case can either be dismissed, or they can be called what's a de novo review, where if a court commissioner instead of a judge is the one who presided over the hearing, then any party can request a do-over with the judge, or the case can be bound over for a final hearing that, like, yep, there's probable cause to believe those three things are true, or it can be changed to either a guardianship and protective placement, which are usually utilized for permanent mental illnesses like Alzheimer's or brain injury that can't be treated usually with medication, or an alcohol commitment, which is the standard for an alcohol commitment is that the person is alcoholic in such a manner that it's affecting their social and economic well-being. So the case can actually switch types of case at the probable cause hearing. I always like case dismissed. Once the probable cause hearing occurs, the subject will be in between the probable cause hearing and the final hearing. They will have two evaluations done, one by a psychiatrist and one by a physician. And then the person can actually ask for their own independent evaluation as well if they want to get a third opinion. And the evaluator usually fills out this form. There's a standard form for it. I've seen a bazillion of these in my time where an evaluator meets with the person and writes down what they talked about and what their opinions are relevant to the commitment proceedings. The final hearing needs to occur within 14 days of the probable cause hearing. The standard of proof goes up, or the burden of proof goes up to clear and convincing evidence. Again, the rules of evidence apply. The subject might ask for a jury trial, or they might not. They might have the judge decide it. And again, our basic constitutional due process rights apply. So 14 days. At the final hearing, two different things can happen. Either the case can be dismissed, or they can be committed, and a commitment order can be in place. And while the jury gets to decide whether the elements for a commitment are met, it's a judge who makes the decision about the least restrictive environment available for the person and whether the person should be subject to an involuntary medication order. Those are not decisions left to random lay people on the street. Those are left to the judge to decide, who probably doesn't have any more expertise than they do. Sometimes subjects appeal their decisions, and then if they don't like what happened, they have to file a notice of intent to appeal within 20 days. So we talked about this briefly, but the 5 standards of dangerousness, one is harm to self, which usually is evidenced by recent threats or attempts for suicide and great bodily harm. And I'm just seeing the chat. I think these are all, okay, good. I just want to make sure there weren't questions in the chat. You can totally put questions in the chat if you'd like. I will take a look at them. The second standard, which I have a video here that I honestly don't want to play because I want to make sure we're being efficient with our time, but harm to others. If the person posed a risk of violent people or violence towards another person, they might be dangerous. They could have the impaired judgment standard, which is a pattern of behavior that induces an inference of future harm. The number 4, unable to meet the basic needs. And this, again, maybe might be the person who doesn't appreciate that they need dialysis. Or again, what I call the unconstitutional 5th standard, which has still been upheld as constitutional, but I think it's as constitutional, even though my defense attorney hat, I think it's a little reductive in its logic. That slide isn't there. All right. That's a very quick down and dirty of the process, but I want to talk about more of the interactive learning objectives of identifying the legal limits to expert opinion testimony for medical staff in these cases, okay? So the rules of evidence do apply, and what that means, the most basic rule of evidence that applies to witnesses testifying is hearsay, and you can't testify about hearsay. So what is hearsay? The law says that hearsay is a statement other than one made by the declarant, so like the person making the statement, while testifying at trial, and it's offered in evidence for the proof of the truth of the matter asserted, okay? So the example in that little diagram is, I saw D stabbing his wife. Yes, that is fine. That is not hearsay. But if he says, A told me that he saw D stabbing his wife, that's hearsay. You're testifying about what another person said. There are some exceptions to hearsay, and one of the biggest ones is by the party opponent. And so if you are a medical professional testifying in a Chapter 51 proceeding, you are allowed to testify about what the subject told you. That's fine. You are not allowed to testify about what their mom told you, or a different staff member told you, or the police officer told you, or what you read in a record. That's hearsay. So I want to practice a little bit. We're going to start an easy one. If you want to put your answer in the chat, or if you just want to do it in your head, that's totally cool. The question is really, is this cool to testify with or not? It's either yes or no. Yes, this is fine. No, it's not okay. So this first one, the medical professional testifies, quote, the statement of emergency detention indicated that the subject was swinging his arms wildly at the emergency room staff, almost striking a nurse in the face. Yes, that's okay, or no, it's not. You can either think about it. If you want to put it in the chat, that's totally cool. That is hearsay. It's what somebody else said. You didn't say it. The person didn't say it. You're hearing it secondhand. Okay. Here's a little bit harder one. The subject told me that he walked out into traffic with the hopes of being struck by a car. Yes, that's okay, or no, it's not. What do you think? That's fine, because it's the subject. It's a party opponent. Okay. Well, and last one, a little bit harder. I reviewed the subject's notes from the hospital, and staff reported that the subject refused to eat or drink without being prompted. And this one, there's actually arguments either way, because one of the exceptions to hearsay is business records. And so if a business record is kept in the normal course of business, somebody can testify about what they read in the business record. If I'm the defense attorney, I'm objecting to that statement, but it might get that objection might get overruled by the court. So that's your down and dirty hearsay. Did the person say it? Cool, then it's not hearsay. Did somebody else say it? Yeah, then you probably can't testify about that. The other thing that comes up is expert opinions, which medical staff need to give. You are the experts for one of the elements of this offense, the mental illness, the developmental disability, or the drug dependency. So what does the law define as an expert opinion? It says that if scientific, technical, or other specialized knowledge, so I'm a lawyer, I don't know anything about how to diagnose people, DSM-5, nope, I can't do that. I don't have that specialized knowledge. And if the person is qualified as an expert by their knowledge, skill, experience, training, or education. So you went to medical school, you went to nursing school, you got this degree, you got that certification, you went to that training, you learned how to apply that expertise, then you may testify in the form of an opinion. And when I say opinion, I actually mean, I think this person has bipolar disorder. That's in the law treated more like an opinion. I think that it can be construed kind of as a fact, but when we're thinking about fact versus opinions, a fact is like, at this time, the bus hit the person, or those are more objective, observable things. Expert opinions, which are deemed factual in court, they're more abstract concepts. It's not like you could observe it with one of your five senses. It's a conclusion drawn by an expert. And so we call it an opinion, but it's given the weight of fact in a court proceeding. So expert opinions are vital. Like, I've never had a Chapter 51 case where an expert in the medical field didn't testify, or at least if they didn't, then I won the case because they couldn't testify about the essential elements. So, but this is also a tough area of the law, because what qualifies as an expert opinion in these Chapter 51 proceedings? And I think that the law and prosecutors and even the court forms are a little misleading on that, and I'll show you an example as to why. So let's practice for a sec, okay? We're going to see is this a legit expert opinion? That's what we're going to ask for these practice questions here. So it says, first, the witness testified as to their qualifications. Yep, I graduated from UW Medical School in this year. I did my residency there. I now practice here. I'm board certified. I'm in good standing on all my licenses and certifications. Cool. You have the requisite knowledge, skill, and expertise, and you could be qualified as an expert, but can you apply your expertise in this case? Let's see. I met with the patient and I reviewed collateral sources, and based upon the symptoms, I can diagnose the patient with unspecified schizoaffective disorder. Yeah, that's like textbook, okay? They have qualifications, they applied their qualifications to the specific facts of the case, and they rendered an opinion in the form of a diagnosis. Cool. Absolutely legit. I have no basis to object to that. Okay? Now, this one's a little tougher. Okay? The witness, again, testifies as to their qualifications. I went to medical school. I'm board certified. I'm still legit. I'm still licensed. And then I say the patient is likely to exhibit symptoms of risky behavior in the future based on the diagnosis and the history of jumping out of moving cars. Okay, so is this okay? Just think about it some more before you I'm not going to tell you the answer right away. Think about what part of that statement requires expertise. Okay, can a lawyer, can a mechanic, can a bus driver, can a teacher testify as to what symptoms somebody might have with a particular diagnosis? No, they really can't. So that first part is totally fine. You can testify about what symptoms are for a particular diagnosis. The part that will be objected to by even a decent or even a mediocre defense attorney is this comment about jumping out of cars. Because while medical professionals are allowed to review collateral sources, okay, you're allowed to review hearsay in informing your expert opinions. So you can say, well, I read this report, I read the ED statement, I talked with parents, I talked to his primary care provider. All of that information is hearsay. So you can use that for forming the basis of your expert opinion, but you can't testify about what that stuff was, at least for what we call the truth of the matter asserted. And what that means is you can say, yeah, well, they have a history of jumping out of moving cars. You can say that as a basis for your opinion, but a judge cannot consider that statement as a factual truth. It's not yet, because we don't have any of the person who testified. We don't have a person who testified who actually saw the jumping out of the moving cars. So a lot of medical professionals will testify in this way, the records clearly indicate that these symptoms are likely to continue, and that's fine. But they also, I see experts, I see doctors, nurses, whoever, want to tell the story of the person from their review of the collateral sources, and that can get into trouble. And to that point, this is a really hard one, okay? This is like the third or fourth page of the standard form for one of those evaluations. So an evaluator meets with the person and has to put forth an evaluation about, if you see at the very top, it says the subject individual is either mentally ill, drug dependent, developmentally disabled, or none of the above. So these evaluations that get ordered by the court for the person in between the probable cause hearing and the final hearing, they're so the court can know and the prosecutor can know, does this person have one of these three, threshold criteria or diagnoses that we need before we can even analyze dangerousness and, treatability? Because that's one of the elements that needs to be proven in the case. Okay. But what this form does that drives me, defense attorney, nuts is it asks you, the medical professional, the psychiatrist, the psychologist, the physician, the medical person, whether this subject is dangerous. And the Court of Appeals is actually agreeing with defense attorneys on this right now. But there's no DSM-5 diagnosis of dangerousness. You could diagnose likely symptoms of a disorder, that this disorder tends to lead to this symptoms, but the form is asking you to render an expert opinion about whether the person is dangerous. And under the law, the only people authorized to make a decision about dangerous are either the judge or the jury after hearing all that evidence. You're not an expert, at least under the law, under these 5 standards of dangerousness. You're an expert in your field. You're a medical professional. You know how to diagnose and you know what symptoms they are. It's up to the jury to decide whether those symptoms and whether that behavior means that the person was dangerous. So when I was in the trial division, I objected to this form being used because I think it asked to put the medical professional in a situation to render an opinion that they're not qualified to give, at least under the law. And clearly, I'm not saying that some specific diagnoses don't carry with them symptoms that are dangerous. That's not what I'm saying at all. But what I'm saying is this form is essentially asking you to conclude that with certainty and in an abstract generalization, yep, this person's dangerous. And I ask you, there's no DSM-5 diagnosis consistent with dangerousness under Chapter 51. There's just not. There's stuff that overlaps. There's supporting evidence that, yes, the symptoms of the diagnosis might be reason for somebody else to conclude that they're dangerous. But when doctors check this form, I think they're being asked to render an opinion outside the scope of their expertise. And they get super frustrated with me when I'm like, I object. And well, the form said so. And I know they're dangerous because they have schizoaffective disorder. Well, no, you know they have schizoaffective disorder. You don't know that they're dangerous because that is a very specific, express legal question that only a judge or jury is authorized to give. So that one's a hard one. And that's with our down and dirty learning objectives, this first one was really related to hearsay. If you know something, cool, doesn't mean that you're going to be allowed to say it in court. And the stay in your lane thing. If you go in there and say, well, I know he's dangerous. It's well, no, he has schizoaffective disorder, which can be dangerous in certain circumstances, but that's the next question that somebody else gets to answer, not you, the medical professional. So with a few minutes left, this is the shortest of our 3 learning objectives anyway. Practice some formal and informal interactions with defense attorneys and prosecutors in these proceedings. So I'm going to use a real story. Some of you may know her, I guess. She's actually a good friend because of our interactions. Sarah Hendrickson. She's the head of the crisis unit at Journey Mental Health. And this is obviously fake, but this is a chunk of an emergency detention statement where I indicated that Sarah was the crisis worker who approved the emergency detention. And so I called her when I actually would have her. I called her and I'm like, hey, what'd you think of my client? And the first time I did it, she's like, I don't want to help you. And I was like, why? And she's like, you're just going to use what I say against me. And I was like, yeah, that's like my job. If my client doesn't want the commitment, then yes, I'm going to do everything in my power to avoid them getting that commitment. But let me tell you why you should talk to me anyway. And so we had this talk and I said, look, it's just fair. If you talk to the prosecutor and you not talk to me, that's not fair. Like there's a general fairness going on here. You want me to come in less prepared just because you feel like you don't like the position I have to take. And that one, she was like, I don't care. But I said, well, fine. Do you want to avoid the accusations of bias? Because if you don't talk to me, I'm going into this hearing and I'm asking you, hey, Sarah, Miss Hendrickson, isn't it true you had a lengthy conversation with Corporation Counsel prior to this hearing? And isn't it also true that you refused to speak to me? Why? Because you want this case to end a certain way, so you have a particular bias, and so therefore you can't possibly giving objective information. Like, I walked her through how I was going to taint her testimony if she didn't talk to me. That got her. And then I think on a more kind of altruistic level, I'm like, look, Sarah, I'm a decent human being. I'm going to do my job, but I promise you, in my private conversations with my clients, I'm going to talk to them about what the help that they may really need. And I will advise them about getting some help. And if they say, I don't care, Matt, I want you to avoid, get this case dismissed, I will work very hard to do that because that's my job. But I promise you, I'm a human being too. And I will talk to this person about what would be good for them. And then she was like, fine, whatever. So, and again, there are reasons not to talk to defense counsel, to avoid giving the defense anything to work with. And as I accused Sarah of, just to be mean, but we have a good working relationship. So not really, but. So how is the prosecutor going to get the treating provider's information before the hearing? So if you are treating somebody because you're at the ER, because you're their primary care doc, because whatever, you're on the psych unit, how are you going to interact with the prosecutor prior to either the PC, the probable cause hearing, or the final hearing? Well, they may subpoena you just to cover their butt that we have this person set to testify. They might call you. They might email you, but if they email you, I'm going to ask for those emails. And so Corp Crestone doesn't like emailing because they like to not have a record of things. But they'll try and get a hold of you at some point prior to the hearing. And if you're one of the evaluators, how is the prosecutor or the defense counsel going to talk to you before that final hearing? If you're picked to be one of those evaluators and you're meeting with the person, either attorney might give you a call, they might email you, they might make a discovery demand. And one thing that as a defense attorney I would do pretty frequently is I would ask like the person, what collateral sources did you review? And so they would need to be ready to share that for the final hearing. And that is my last slide for questions. And we are at 12:58 on my clock.